Question 411. The appraisal method usually relied upon by real estate professionals is the A. Cost approach, B. Capitalization approach, C. Market approach, D. Sales replacement. Correct answer is C. Market approach. The market approach estimates the value of a property by comparing it to recent sales of similar properties in the same or comparable areas. This valuation method is preferred as it directly mirrors the present attitudes and behaviors of buyers and sellers in the market. Consequently, it serves as a reliable indicator of fair market value for standard residential sales when ample comparable data exists. Appraisers analyze these comparable sales, making adjustments for differences in features, condition, location, and time of sale to arrive at an estimated value for the subject property. The cost approach, valuing based on rebuilding costs, suits new construction and unique properties. The capitalization approach, based on income generation, applies to investment properties. The market approach's reliance on comparable sales makes it the most relevant for typical home transactions. The market approach is the primary valuation method for residential real estate because it directly reflects current buyer and seller actions. Its direct link to market activity provides a strong indicator of fair market value. Question 412. Harry makes a written offer to purchase real property, but before learning whether the seller accepted it, Harry is killed in a car accident. What effect does Harry's death have on the offer? A. Once the administrator of Harry's estate is notified of the seller's acceptance, the contract is binding on the estate. B. Regardless of the timing of notification, the offer and its acceptance create a valid contract. C. Harry's death served to revoke the offer. D. If the car accident resulting in Harry's death occurred after the offer was accepted, it is binding on the estate. Correct answer is C. Harry's death served to revoke the offer. In contract law, the death of the offeror, the person making the offer, generally terminates the offer, even if the offeree, the seller, is unaware of the death. An offer requires a living offeror and offeree capable of entering into a contract. Notification to the administrator after death cannot retroactively create a contract. If acceptance occurred before Harry's death, then a valid contract would have been formed, and it would generally be binding on his estate. However, the scenario presented states that Harry died before learning of acceptance. Question 413. A developer who wishes to sell subdivided lots from his subdivision located in the middle of a city must first A. Provide buyers with a copy of the Real Estate Commissioner's final report on the subdivision. B. Obtain a signature from the buyer verifying his receipt of the report. C. Provide the city with his financial statements dating back 10 years. D. Both A and B. Correct answer is D. Both A and B. The subdivided lands law requires, among other things, that the Commissioner's report be furnished to customers, with their signatures verifying receipt. This report, also known as a public report, discloses vital information about the subdivision for potential buyers. It includes details like developer information, infrastructure details, roads, utilities, financial arrangements for improvements, homeowners association information, if applicable, potential assessments or fees. These requirements help protect consumers by ensuring they have access to crucial information before entering into a purchase agreement for a lot in the subdivision. The law does not apply to subdivisions located in a city if the subdivision has no common area, nor does it apply to subdivisions located in unincorporated areas. Question 414. While working with a subdivided property for which the Commissioner's preliminary public report has been issued, a real estate agent can A. Accept a listing for the property. B. Accept a purchase offer and take a deposit. C. Lease the property without selling it. D. Accept an exclusive listing without a termination date since it is uncertain how much time will be needed to sell all the lots. Correct answer is A. Accept a listing for the property. Preliminary Public Report, PPR, allows a subdivider to begin marketing and taking reservations for lots within a subdivision before the final public report, FPR, is issued. However, there are restrictions on what actions can be taken. Real estate agent can generally accept a listing for a property within a subdivision that has a PPR. This allows the agent to prepare for the eventual sale of the lots once the FPR is issued. Agents and subdividers can accept refundable reservation fees before the final public report is issued. However, they are prohibited from entering into binding purchase agreements or accepting non-refundable deposits until the buyer has received and had a chance to review this report. Leasing the property might be permissible depending on the specific circumstances and any conditions outlined in the PPR, but it's not the primary activity facilitated by a PPR. California law requires all exclusive listings to have a definite termination date. This applies regardless of whether the property is part of a subdivision with a PPR or a fully approved development. An open-ended listing is illegal. Question 415. If a real estate agent commits an act violating the real estate law, the real estate commissioner can discipline the agent for the violation up until A. The agent moves to another state. B. 3 years after the violation. C. The agent's license expires. D. Never. There is no time limit on the commissioner meting out discipline for a wrongful act. Correct answer is B. 3 years after the violation. California law sets a statute of limitations for the real estate commissioner to initiate disciplinary actions against a licensee for violations of the real estate law. This period is generally 3 years from the date the commissioner becomes aware of the violation. The commissioner's disciplinary authority is tied to the agent's California real estate license, regardless of their residency. Even if an agent's license expires, the commissioner can still take disciplinary action for violations that occurred while the license was active, as long as it's within the statute of limitations. The standard period in California is 3 years from the commissioner's awareness of the violation. Question 416. A real estate agent did not mention to a client that the property he was being shown had been built near a major ground fissure, and was subject to frequent earthquakes. The client made an offer on the property, and put down a deposit. If the prospective purchaser then finds out about the earthquake issue, he can A. Ask for the contract offer to be rescinded. B. Report the lack of disclosure to the state attorney general. C. Ask for a novation of the contract. D. The offer must be honored by the buyer. Correct answer is A. Ask for the contract offer to be rescinded. Real estate agents in California have a legal and ethical duty to disclose all material facts about a property that could affect a buyer's decision to purchase. The proximity to a major ground fissure and the property's history of frequent earthquakes are significant material facts that could substantially impact the property's value, safety, and desirability. The agent's failure to disclose this crucial information constitutes a breach of their duty to the buyer. When a seller or their agent fails to disclose material facts, the buyer has grounds to seek rescission of the contract. Rescission is the unmaking of a contract, returning both parties to their original positions as if the contract had never been formed. The buyer was operating under a lack of full information due to the agent's failure to disclose a material fact. They are not obligated to honor an offer made under such circumstances. In this case, the buyer would likely be entitled to the return of their deposit. Question 417. A deposit on a real property transaction can never belong to A. Broker. B. Seller. C. Buyer. D. None of the above. Correct answer is A. Broker. Earnest money deposits, the deposit on a real property transaction, are considered trust funds. The deposit initially belongs to the buyer. It is their money offered in good faith to secure the purchase. If the buyer has a valid reason to back out of the deal as per the contract terms, the deposit may be returned to them. The deposit will eventually belong to the seller if the sale closes according to the terms of the agreement. It serves as a form of security for the seller. Brokers hold these funds in a trust account on behalf of the buyer and seller, according to the terms of the purchase agreement. The broker acts as a fiduciary, meaning they have a legal and ethical duty to act in the best interests of their clients and to handle trust funds responsibly. The deposit does not belong to the broker personally. Question 418. Which of the following relationships create a fiduciary responsibility? A. Seller's broker to the seller. B. Trustee to his beneficiary. C. Buyer's agent to the buyer. D. All of the above. Correct answer is D. All of the above. A real estate broker acting as a seller's agent has a fiduciary duty to the seller. This means they must act in the seller's best interests, with loyalty, obedience, disclosure, confidentiality, accounting, and reasonable care. They must act in the buyer's best interests, with the same set of fiduciary duties: loyalty, obedience, within legal and ethical bounds, disclosure, confidentiality, accounting, and reasonable care. In a trust, the trustee holds legal title to assets for the benefit of the beneficiary. The trustee has a strict fiduciary duty to manage those assets prudently and in the best interests of the beneficiary, adhering to the terms of the trust. Like a seller's broker to the seller, a real estate agent acting as a buyer's agent has a fiduciary duty to the buyer. Therefore, all the listed relationships involve one party, the fiduciary, having a legal and ethical obligation to act in the best interests of another party, the principal or beneficiary. Question 419. The following statements are true about VA loans, except A. A veteran's VA loan is assumable only by another veteran. B. A veteran's particular guaranteed loan amount is called her entitlement. C. A veteran's guarantee rights are reinstated if he sells the property with the VA loan, then repays the loan in full from the proceeds of the sale. D. VA underwriters rely on the debt-to-income ratio to assess if a veteran meets qualifying standards for a loan. Correct answer is A. A veteran's VA loan is assumable only by another veteran. While VA loans offer significant benefits to eligible veterans, one common misconception is that they are only assumable by other veterans. In reality, the assumption of a VA loan is not restricted solely to those with military service. Non-veterans can also assume an existing VA loan, provided they meet the stringent creditworthiness and income standards set by the Department of Veterans Affairs and the lending institution. This allows a broader pool of potential buyers to consider properties financed with VA loans, potentially making the property more marketable. However, it's crucial to note that when a non-veteran assumes a VA loan, the original veteran's entitlement, which they used to secure the loan, is not reinstated until the loan is fully repaid. Conversely, several other aspects of VA loans are accurately described. The entitlement represents the specific guaranteed loan amount available to a veteran, providing lenders with security and enabling veterans to often purchase homes with no or low down payments. Furthermore, a veteran's entitlement rights can typically be restored if they sell a property financed with a VA loan and fully repay the outstanding balance from the sale proceeds. This allows veterans to utilize the VA loan benefit multiple times throughout their lives. When evaluating a veteran for a home loan, VA underwriters heavily consider the debt-to-income ratio. Alongside this, they calculate the residual income, which is the money remaining after monthly expenses. This comprehensive assessment ensures the veteran can comfortably manage the mortgage's financial obligations. Question 420. A Florida resident who is the owner of property in California dies while vacationing in New York. Where will the property be probated? A. New York. B. California. C. Florida. D. None of the above. Correct answer is B. California. Real estate is generally subject to the probate laws of the state in which it is located. This is known as ancillary probate when the deceased was not a resident of that state. The main probate proceedings for the deceased's estate will likely take place in Florida, where they were a resident. This will handle their personal property and assets located in Florida. Since the deceased owned real estate in California, an ancillary probate proceeding is required in this state. This separate legal process will transfer the property's ownership according to the deceased's will or California's intestacy laws if no will exists. New York is irrelevant as the deceased only died there while on vacation and was not a resident nor owned property there. Therefore, the California property must be probated in California.